let's get going. On the blog, which everyone who's contributed, it's been really fun so far, so I hope you guys are going to hang out more, post more. Everybody knows that you can now not only respond, but actually initiate posts. So there would have been an email that would have come from UBC, not from me, asking you, I think, to click on a link. Make sure you've done that. And the blog site is open to anybody, so anybody could respond. But what would be cool would be to see even more people initiating. I'm certainly having fun with it. Last week's News of the Week is up there, and I will put this week's up. I doubt we will have time to get to it in class. I've also revised the syllabus on there and will continue to revise the syllabus on there to try and minimize paper use. In terms of changes, it looks like Jazz Purewal, who is certainly, in my view, the leading actively practicing video game lawyer in the world, will be joining us from London through the magic of video conference next week. So next week's group, please come see me after class, and we can talk about how that is going to go. We have a wonderful guest for the second hour, but before we get there, you need to put up with me. So today, you will notice that I keep changing the titles of my talks slightly, seeking clarification. We are going to finally get at the right to create, which we've been teasing at for about 2 weeks. Where are we? So the first rubric in the course is called Creating, to be followed by Connecting, Controlling, and Challenging. And this is the third and final talk under Creating. Talk 1 was about games, legal recognition, and the consequences of legal recognition. Last week was about constraints on digital creativity. And today, head on, is there a right to create? Is there a right to mod? Should there be? Could there be? Where are we? That is not an inconsequential question, as we will get to. But first, follow up to last week. I left off with the crazy notion, or slightly crazy notion, that economic success, notions, deeper notions of justice, and facilitating creativity could all somehow be wrapped together. And there was research of a very loose kind that at least found a correlation between strong economies and weak IP laws. I found that wanting, being a Western liberal, and wanted to introduce some notion of fundamental rights to that equation. Did deep Google research of 5 minutes and found correlations between economic success, creativity, and fundamental rights in Sweden, but never followed through. Said, gee, I wonder if Sweden really is strong at facilitating creativity. And then I was tweaked by one of your classmates, Zohar, who will make a couple of observations, and then I'll follow up with some sites.
Sweet. So yeah, I I found a couple documents that I can either post on the blog later if that's what people want, or I've emailed them to you as well, that speak to a concerted effort by the Swedish government to broaden their innovation sector, technology sector. And then an interesting article that I just came across that shows that, I mean, we know a lot of these names, but I didn't really know they were all from Sweden, but Spotify and Skype, which a lot of you know, are Swedish, but so is SoundCloud, which is based in Berlin now, but started in Sweden. Same with, what was the other one? They had Kazaa was Swedish.
Oh, I didn't know Kazaa was Swedish.
And yeah, so it seems like, and the Pirates Bay, obviously.
So a proud heritage of IP openness, let's say, in Sweden. The two sites that I found, the first one is particularly interesting because it's an official Swedish government site and piece of writing. And when you read it, you may come away saying, gee, that doesn't sound like anything our government or the US government might write, because it really celebrates IP content liberalism. And remember, this is coming from a government source, not from an academic or a user. And then a very interesting blog post on a similar course to ours, more on the technology side, from Yale, called The Pirate's Life in Sweden.
I thought Kazaa was actually Dutch originally, and that they've been forced to move because they've been under a fair bit of attack. But I could be wrong on that.
Well, the original thesis from last week was that part of the world.
Yeah.
So we'll go with that. So today, is there a right to mod? Is there a right to create? And why is that important? It's important for the reasons we talked about in the first class. With video gaming being the apex of interactivity, if a right to mod and right to create exists, then other remixing rights may have a better chance, or they may not. And in fact, that's going to be a question for you, possibly a question for your papers as we go through both today's class and the course generally. So resistance to the right to create, and forgive me for the cheap shot, but I totally love this one. Modding, as almost everybody knows, is taking a game, creating levels, creating skins, creating a game within a game, changing the game. And very often developers and distributors of video games get their backs up, understandably, based on IP law. And some allow for modding, some are dead set against it. The core of the anti-mod sentiment is neatly set out in a quote: "We believe it is our duty to uphold the integrity of our work." And that was from the general manager of Tecmo, when Tecmo decided to sue a group of modders. The problem is that the game that group of modders was changing was something called Dead or Alive Extreme Beach Volleyball. So the word integrity doesn't necessarily live as large in that context. At the very least, a profound absence of understanding of the ironic. So for the next 45 minutes, what should you be thinking about? Well, I can't ask you to think about anything in particular for more than 45 minutes. Think about personal creativity. As we go through this, focus on personal creativity, and oddly, the personal part of personal creativity first, and think about interactive environments. Interactive first. But note that you can also think about personal interactivity in a creative environment, and you'll actually get to the same place. You may want to look at this slide at home and figure out if you can find a flaw in its reasoning. Ultimately, ask yourself whether gaming is the same or different as more one-dimensional, less interactive mediums, TV, film, and then same or different as other interactive mediums, events, being sports and music. And I did something unusual here that intuitively feels right, but feel free to criticize it. I put music in with sports because there's an interactive component to music that feels very real to me. You put on music, people dance, people react, people sing. Please.
I would think sometimes I think of this not even in terms of interactivity. I mean, let's say you've got a nice painting like the Mona Lisa. Nobody wants me to go to the Mona Lisa, draw a mustache, or change the clothes she's wearing or anything like that. But if you take a reproduction of the image of the Mona Lisa and mod it, Photoshop it, do something else to it, you're preserving the original artist's intent and letting other people enjoy it, but at the same time you're able to do something else with it.
And you're going right to the core of where I hope we go over the next hour. But that's right. It's more than personal interact. It's more than interactivity. And it's a layered creativity based on something else. Now, that's what modding is. When you move it away from the interactive space, and you keep the two-dimensionality, it's a bit problematic because the most famous and certainly amusing recent art mod, and you can look it up online, was the elderly woman who altered a famous drawing of Jesus, I believe it was, and in many eyes of art critics and non-art critics, completely defaced it and ruined it. And then when it became an internet meme, sued because her copyright had been compromised. I mean, it was all messed up and legally holds no water and wasn't going to go anywhere, but it does speak to what is a mod and what isn't a mod, and by the end of this, we'll get to a place of talking about moral rights and where they may fit into this dialogue.
So when you're modding something, like, are you not manipulating the original copyright of the code? Like, so who's to say that copyright in a painting is more important than copyright in a computer video game code? It's the same manipulation of the same original source of the content.
Awesome question. And let's go at it directly, because modding can mean manipulating code, and in other cases, it doesn't mean manipulating code. And so we're going to go through the actual cases that we would have to overcome if we want to establish a right to mod, and see if we notice anything in particular.
When you talk about integrity of a work, what exactly do you mean? Do you mean you're looking at the work apart from the effort and the hours that went into it, or do you consider it more holistically in terms of, regardless of the end product, the value of the work or the degree to which it should be protected is proportional to the amount of effort that went into it.
Well, how I may look at it pales in comparison to how the law will look at it. And the law will look at all of those things. But I think when we look at it in a moral rights context, then it does become holistic. And that will be kind of the very end of this slide and a tease, this talk, and a tease to later dialogue. But yes, personally, I look at it as a holistic, question in terms of what is the integrity of your work, but then what are your rights to protect that integrity? And is copyright, is the economic right associated with intellectual property part of that right, or isn't it? So that's hopefully some of the questions this will raise in your mind. So all of these cases that we're going to talk about, you've heard about in various forms from Rock or I previously, but just to quickly go through them, and you have them all either through the text or referred to in the syllabus, and they're all accessible. Microstar and FormGen. So Microstar was a company that went out and collected a whole lot of Duke Nukem 3D levels that had been made by the modding community with permission under the end user license agreement from the makers of Duke Nukem. So the community gets out there, creates levels for Duke Nukem, hundreds of them. Company comes along, scoops them off the net, never talks to any of the community who made the levels, takes all the levels, puts them on a CD, and sells the CD for money. It's not a compilation made available for free. Microstar makes a fair use argument. Should not be surprising to anyone that it fails. Next case. Davidson, which you've also heard about. No reason to explain why it's called Davidson and Associates. It's all corporate bump. It should be called Blizzard versus Internet Gateway. Blizzard makes StarCraft, Warcraft, and created something called BattleNet, which allowed online player versus player gaming long ago. The community was unhappy with the original iteration of BattleNet because it included commercials and it included ads, and it was very buggy. Very, very buggy. So group in the community reverse engineered it, which you're allowed to do under copyright law in and of itself. Reverse engineered it, fixed all the bugs, and made it available for free. They actually went so far as to ask Blizzard if they could get the key that would ensure that only authorized copies of StarCraft, I think was the game in question, could be used with the BattleNet replacement, which was called BNETD. Somewhere in the case you'll find why it's called BNETD. It was a distinctly disappointing reason. You hope for something better. It was purely technical. In any event, Blizzard refused. Blizzard sued. Blizzard succeeded based on end user license agreement and terms of use prohibition against reverse engineering. Talked about iRacing last week. And iRacing succeeded against Robinson, who had made a mod which modified the executable. So modified code. But bifurcated contract law and copyright law and said that fair use exists to the copyright, fair use exists as a defense to the copyright claim, and the contract claim under the end user license agreement or terms of use is a different claim with a different result.
And what would the difference in remedy be?
Well, the difference in remedy is in contracts, you're going to have damages, as we discussed last week, and in the intellectual property claim and the copyright claim, if it succeeded, which it did not have to here, you are more easily going to get an injunction. The last case is the bot case, which Rock talked about, which really built on iRacing and Robinson. And it's an interesting concept, and we don't have time to dig into it, but it's a really nice foreshadowing of user rights. So here you have a company that makes bots that are prohibited by the end user license agreement in terms of use. The bots actually don't modify the actual content of the game. Think of them as an add-on. And this goes to Michaela's question of earlier. Are you actually modifying the code, or are you building code that changes the game? And I'll give you I'll go back to one footnote on that in a minute. So you have these bots. MDY is successfully sued by Blizzard under the Digital Millennium Copyright Act because they circumvented certain things. But the court says that the users of the bots, the users of the MDY bots, are not liable, and MDY is not liable for the fact that users used something that was prohibited. And so it's a bit complex. I would refer you to the Electronic Frontier Foundation link, a mixed Ninth Circuit ruling in MDY versus Blizzard. WoW buyers are not owners, but Glider users are not copyright infringers. So it's a good piece and should help explain the case. But again, we come to, you know what? Let's just go back. Do you notice any common denominators among these four cases? Okay, I want to add a fifth case. It's an earlier footnote. All this started with a case called Louis Galoob and Nintendo versus America. This again goes directly to Michaela's question. Something called the Game Genie. Anybody remember the Game Genie? Yes, excellent. So the Game Genie changed parameters of the game, but it did so without altering any code. So if the game allowed you 3 lives and you wanted 10, by using the Game Genie, you could alter the parameters within the game. But when you unplugged the Game Genie, it left the intellectual property of the game. It left the cartridge. It left the NES system completely intact. It changed nothing. And court found the Game Genie and the makers of the Game Genie to be free and clear of any liability, and found fair use. Okay, common denominators. Go right ahead. Creativity is not an issue in any of these cases. But what about yeah. Please go backwards. What about form gen? There was creativity, but it was the creativity of the mod makers, not the creativity of the defendant. MicroStar didn't do anything creative. They gathered other people's creativity and put them on a disc. Yes, was there cover art? Yes, but please, if that was the question.
Which maps did they pick? Part of the compilation. Were they the good ones, the bad ones?
The issue, that issue is whether there would be intellectual property in what they did.
I'm saying there's creativity in the compilation.
Okay. I understand this creativity in the compilation, but they didn't make any mods. And the question is right to mod. And what the court said was there isn't a right to gather up a bunch of other people's mods and sell them. So our question for today is there a right to mod? And I'm saying, and you may disagree, MicroStar didn't mod. Second common denominator. Copyright law really only comes up in MicroStar, which, for the reasons I hopefully just explained, is not really a modding case. And Galoob, which goes in favor of a right to mod. So the rest of the cases are contract cases. They're all end-user license agreement TOS cases, where copyright law gives way, and the right to reverse engineer under copyright law gives way to contractual agreements between the game maker and the player. So where I suggest this takes us is that there is no precedent that game mods are not fair use.
Do you think that the courts might have wanted to deal with these more on contract law because that might have been a little more clear cut as opposed to trying to wade into this new area of emerging technology and issues and IP things that are coming up?
I think that's a big part of it. I'll make one observation. In the last talk we're going to have this year, I'm going to play you excerpts, and you have it on the second to last. I think it's second to last talk this year. That's right, class 12. I'm going to play you the oral arguments in the BNETD case in the Court of Appeal. And what you will hear from the excerpts, as soon as I figure out how to cut and paste those into an orderly way, is Blizzard's lawyer, who was successful and who was fantastically good, desperately avoiding the issue of creativity, running as far away from it as he could in the opposite direction, and characterizing the creation of BNETD over and over again as a purely technical exercise with no creativity in it. So yes, the bogeyman, I think, to everybody, and rightfully so, when you want to be cautious as a court, is, gee, something is changing here. What does all this creativity mean and how does it fit in? It is no simple task to parse this out.
Wouldn't there be a huge distinction based on whether modding is commercial or not? Like even if Microstar had made all 300 of those levels themselves?
So, well,
If you're only relying on fair use.
That's the question. And you need to go to Galoob and go to the case, because one of the factors in Galoob that they mentioned, but the court just went through factors, was whether the mod was for a commercial purpose. But of course, the Game Genie was purely commercial, was sold for money, and the court still went with it. Now, you can also say, well, the court was saying okay to the technology, it's the user who was using the technology to mod the game. So the answer is we don't know, but the rest of the class today is to talk about whether mods can be fair use. All I've done so far is say there isn't a case that prevents a right to mod from existing. I have not established, and we have not together established, that a right to mod exists. Were there other? Okay. So, what's at stake here? Harken back to the earlier slide. Where I asked you to reflect on creativity and I have to remind myself. No. You know what? We won't go there. Harken back to what I asked you to think about, which I've now forgotten. What is at stake? Obviously mods, but then, and you may disagree with this, but the lower order of things. Machinima, not particularly interactive. Fan fiction, sort of. Remixing, again, not particularly interactive. Multi-source content, potentially quite interactive. And the real question, is there a freedom to create or not? Some questions, further questions that I keep alluding to. Does interactivity set modding apart? How important is it? Who owns shared creativity? There are legal answers to this in the copyright world. There's not a lot of answers that have ever been proffered in a fully interactive setting. So when we talk about shared creativity, the traditional perspective is two songwriters who get together. The Sarah McLachlan case in BC. Should there be a joint copyright issued? Now the core. Right to create or creators' rights. Semantics, and Michaela, I'll come to you in a second, but need to establish in your mind two totally different tracks here. Right to create as an expressive right, as something akin to freedom of speech, freedom of expression, freedom of thought. and something that is personal. That was a key word in the earlier slides. Or a creator's right, which is part of copyright, part of intellectual property, and attaches more to the creation than the creator, because the creator can alienate it, can sell it, it can be sliced and diced, as all intellectual property can. The sandbox game, Minecraft, is modding as a game. And if you haven't gone into it, it is well worth your time, both from a gaming perspective and a philosophical perspective. So this is just what I've already said, right to create, being a personal, akin to free speech right. Is it a separate right, or is it part of free expression? Doesn't really matter for our purposes, and we've touched on that in earlier classes. Doesn't really matter where the right to mod comes to exist. Now, what do you prefer? Any thoughts? And Michaela, you had a question, and I may have run over it, so I apologize.
So a couple classes ago, we all agreed there was like a Pong game that you had on a slide with the rainbow colors.
Yes.
So we all agreed that that was art. So let's say instead of manipulating a mod, instead of changing the code, you are adding to it. So you're not manipulating the original copywritten code, you're adding to it. So in that situation, would the plaintiff have a moral rights argument in saying, like, if you change the skin of it, is that not manipulating the art in the way that it's displayed? But then again, like, I was also wondering if moral rights arguments are toothless in this age of IP law.
I can go home now because that's, you've just done it. Yes, that's the question. And no, I don't have an answer. And that's precisely the question that I hope to get to, and you've seen it very clearly. So to put it in context, okay, so moral rights flows from the personal. So where do we go with that? And can we go somewhere with it? And is it a useful tool? The answer is don't know. It's up to the current generation of lawyers and policymakers to figure out if it might be. I will try and show how it might be. But to go kind of back to the threshold issue, what do you prefer? Do you prefer an expressive freedom-like right to create? Or do you prefer a copyright defense, intellectual property defense right to create? And does it matter? I've got a preference, may not be the right one, and you can push back, but we talked about one of the great filters for a course like this is double standards. Where you find double standards, it's probably appropriate to get uncomfortable in law. And I'll refer you to a wonderful piece by Benjamin Hill, called Freedom for Users, Not for Software. And it makes exactly the point that what's happened with even free software is that the restrictions that come through contract law and that are attached to the software become chilling agents on personal creativity and mean that you're not going to go as far as you might. The more amusing and less academic take is, you might remember Bob Dylan being very critical of people who criticized him for borrowing heavily from the canon of folk music and showing how he was extremely influenced. And that in and of itself, certainly to our argument, is probably a good thing. The problem, as this article shows, is and calls out Bob Dylan for being extremely aggressive in protecting his own expression and his own copyrights while being very liberal in approaching other people's creativity. So if you want to go to a single standard, the single standard along the lines of a personal right to create not attached to intellectual property law may be preferable. But, as you will see, it's a difficult place to get to.
Oh, I just have a couple kind of combined thoughts that I think add up to something. So, first, I think that it's probably a good thing to find a middle ground and to strike a balance for each individual case as flexible, like to make that as flexible as possible so contract has that appeal. But I think that just like in real life, the private property interest that you have in something and the right to keep people out of it is what generates that incentive for the other person to come and offer you a contract to use whatever it is that you own that they want. I think if you don't have the ownership first, you can't make you can't strike that balance, even using copyright. So I feel like even though contract is probably the preferable way of achieving the solution, without the property interest behind it, you don't have the right starting point, potentially.
Okay, and that is the state of the law today. And the question is, does digitization, does what it allows for in terms of personal creativity change that? Should it change that in the future? But today, we're where you just set out we should be, Zoe. Any other?
I'm wondering where you would put originality into your discussion of creativity.
I would put it there as very critical.
See, one of the problems I'm having is that I think we're seeing some of the difficulty in IP law between patent, which is based on revealing your invention or discovery, has to be original. If it's not original, it gets challenged and it never gets registered, you get no rights. With expression, which is limited in terms of you are able to use the material in the public domain to craft creation, an expression. It has to be a creative expression. But originality is not really as big a deal there because it's going to go back into the public domain sometime in the later future. There is this interaction, and what I find one of the difficulties with copyright law has been with this whole notion of derivative works. Because people who study literature, people who study art, we found out a long time ago that the whole notion of anyone coming up with something that's going to be brand new, original, is likely impossible. So in copyright law, you have limitations. The Baker-Selden case about various colors, things you cannot in fact copyright. But under patent law, it's a different story. And under trademark law, we had a different story yet again.
Well, let me agree with you, but let me agree with you by making it very simple, I think, and echoing what you've just said. In fact, the current state of copyright law sets a very low threshold for originality. We talked about that in the Otari versus Oman case. That's what that case was about. So when it comes to originality, to fully answer the question, I start by saying I think it's very important, but I'm very non-judgmental about it, and neither are the courts. And neither should they be. So originality is very much part of the creative process, and who am I to judge your creative process? And that, thank you for delivering us here, Ken. I love the first quote. And there's millions of attempts at getting to the core of the creative, but this one, even though it's not about gaming, really struck me as being about gaming. I believe we don't create a fantasy world to escape reality. We create it to be able to stay. And for any of us who are pretty hardcore gamers, that should resonate. And then there's some musings as to why. It's actually a very serious point. And then Salman Rushdie, who I think is quite qualified to talk about creativity, reminds us that there is a chill that comes on to the creator. And that being creative and being in a creative act doesn't just require freedom, but an assumption of freedom. You can't be thinking about what the constraints are to be truly creative. So that fits into the low threshold, because almost anything can chill that.
And one point about the copyright patent analogy, if you want to analogize the two, I don't think they're too different in terms of originality. You're right that you have to convince the examiner or the government that your patent is original before you get it. You don't have to do that for copyright. But in practice, the threshold is still there for both. And what happens if you go to enforce is the originality of your patent will always be challenged in court, regardless of whether it will have been granted, but it will always, 10 times out of 10, be challenged if you go to enforce. And a similar defense holds for copyright. In terms of the originality threshold for copyright being lower because eventually it's dedicated to the public domain, I don't think there's a difference there with copyright and patent, because of course with patent it's also dedicated to the public domain. In fact, sooner than copyright, 50 years for copyright, 20 for patent.
The whole process of getting registered is public disclosure.
That's
And
right.
patent is an entirely different sort of process.
That's
But
right.
there is the whole notion of whether or not it's something that could be anticipated by somebody skilled in the art.
Yeah.
That is not there for copyright in any way. The main reason why there's a distinction made on the particulars of the copyright is to be able to compare, and that's why fixation is so important, to compare one version of a work with another version of the work, and then to apply the various sorts of deeming provisions of, if this one existed earlier than that one, there was access between them, and there's substantial similarity, I can deem that there was copying. Why? Because we cannot actually prove, short of running in and taking a video of somebody working between two manuscripts, we cannot prove, except by that kind of use of indicia and those deeming provisions, that copying has taken place. And it is the copying that is, in fact, the focus of copyright. Where that has fallen down has been in very broad assumptions about what would be a derivative work. And then we've seen an extension more and more, largely because of the association with both the, how do you monetize it, how do you pay the person who has invested the time to make this original creative expression, how do you give them credit? We've given them rights which are do not expire, which are the moral rights, but then we've made it so that they're, at least in our country, you can waive them, but you can't actually alienate them, so that they're not the same as the economic rights that come from the other aspects of copyright. And copyright is in this kind of no man's land in some ways, because people still claim, it's my idea. No, it's your expression of an idea that you get protection for, not your idea. The ideas are everybody's.
Let me riff on that for the next little bit. because that's what's going to happen. So here's, going to do this very briefly. This is my personal moment proving how low the threshold for creativity actually is. You're supposed to laugh now. When I was a little kid, I loved comic books, Spider-Man and the Silver Surfer in particular. Read them obsessively and started drawing Spider-Man comics as a 7, 8, 9-year-old. I was actually a lot better than I am now. And in the context of wondering about creativity, I actually connected with the 9-year-old who had written, and I wish I had them. I think I might still have one somewhere, where I would write full 30-page comic books, script them, tell original stories, have my art, except it was Spider-Man. These were Spider-Man comics, so there was no question that in the contemporary copyright idiom, I was breaching something. Fortunately, there was no audience and therefore no damage. And as I connected to that moment, I found my own creativity, and I remembered how I used to draw. I used to be a lot better than that, and I came up with Creo, derived from the Latin word for creativity, who is my hero, and his enemies are the trolls, I decided. So.
I think they just recently revised the Copyright Act in Canada, so that you can actually reproduce original work.
Yes.
As long as you don't do it for like a profit.
Yes, and that's a very good point. Under the current Copyright Act that just came into force, simply personal use will exempt you.
So
When I was doing the drawing in 65, I probably had more of a problem, but people weren't looking at copyright the same way.
I mean, I think it would have been fine under the old act. I mean, private study, you don't publish it, it's not a violation of anything.
Yeah, but it wasn't. It wasn't. Well, you know what? We'll talk about private study, and in a different class, we will talk about the Supreme Court of Canada's pentology. Although I will quickly refer to it. Bunch of paradoxes. I'll only focus you on one. Intellectual property. Just say those words over and over again. Intellectual and property. They don't go together so well. You can revisit this slide, but I did a little bit of just personal research, and I defy you to go to the Copyright Act, the new one, and look up the word property and where it appears in the Copyright Act. Just the word property. And see if it really means property, because I think you'll find it doesn't mean property. Now, to go to Ken's point, if you look up the word property in the Trademark Act and the Patent Act, it really does mean property. It's much more akin to personal property. For some reason, they stay away from the word property as we understand it in a corporeal sense in the Copyright Act. And intellectual property, remember, is not a legal concept. It's a rubric. So probably attacking something that need not be attacked. But it's certainly the prevailing meme. More reasons why copyright are not property. Pass over that. So Zohar asked the question of whether there's a reconciliation possible. Here's a version of a reconciliation, and I ask you to be patient with me in the sense that, remember that I'm really not an IP lawyer. I am a freedom of expression lawyer. Those are my origins, so I tend to see everything from a free speech perspective. Statute of Anne, as you will know, 1710, was the original Copyright Act. Got curious. What led to the Statute of Anne? What existed before the Statute of Anne? What was the Statute of Anne a response to? Well, first you had all censorious rights belonging to the king. And then, as you will know, presumably from constitutional law, the Star Chamber was abolished, and with it, the de facto cessation of kingly censorship. So the royal censorship machinery was replaced, but there was still censorship machinery, and it was Parliament's. Licensing Order 1643, just watch the timeline here. Parliament required authors to have a license approved by the government before their work could be published. So censorship moved from king to Parliament. Earlier class, we mentioned John Milton, Areopagitica, unsuccessful but brilliant speech to the British Parliament against effectively the licensing order, the licensing of printing presses. Then we moved further. Licensing of the Press Act moved things to sort of an industry association of printing press owners. So the machinery of censorship was now in the hands of the printers. And finally, according to this version of events and this timeline, we move the means of censorship to the creator by the Statute of Anne. So that is a freedom of expression look at contextualizing copyright legislation.
It actually starts a little before.
Awesome.
It starts with, everyone's heard of the Gutenberg Press. Well, Gutenberg Press, of course, enables Luther and a variety of other people with a movable type to start printing Bibles in the vernacular languages. This was something which was not looked upon very kindly by the Roman Catholic Church. The Counter-Reformation is all about trying to put a stop to that sort of thing. That particular invention, the Gutenberg Press, then starts to get exported to a variety of other countries, including England. And the first stationer's licenses come out during the time of Henry Tudor, who obviously wanted to control the press to a certain extent because there was a fair bit of controversy in England about whether or not he was really divorced or not, that it was annulled or not, and there was the possibility of a civil war. 1640, there was a civil war, and that's why you see some of that. But essentially, the king has been losing the ability to control the press through those stationers' licenses. There were about 7 or 8 of them in England. And so eventually, an alternative approach is, okay, we'll put the rights in the hand of the individual author. We'll take them away from publishing companies which have gotten to be too big for their britches, and they bring it in at 17.
So I would love if on the blog you would annotate the slides, because you can now comment on the slides, and I will modify this for the next version. But
what it does is it gives you this sort of timeline, but copyright was originally a tool of censorship to control the various tracks that could be printed on this new technology. Essentially, it was only after they went to 1710 that they had to justify it some other kind of way. One of the ways of justifying it was saying, we're going to encourage creativity amongst the authors.
Okay. So I'm going to hold you there. I've got 5 minutes so that we can get to our guest, 5 to 7 minutes to wrap this up. But the point being, and we're agreeing, there is this trajectory of liberalization and freedom, and you have these steps of king to parliament to industry association to author. I just ask you, how much further in 1710 could this go? That was actually pretty good. There's a lot of liberalization in a fairly short period of time. maybe not a lot has happened since then. And what could you do with a book? Could you remix a book in 1710? We didn't have the technology. The author is the right repository in 1710. So, in the current context, we all notice that it's a bit unusual that copyright constrains speech. Trying to, on a more deep level, make you think about that paradox and suggest that maybe that's why we should prioritize the creative freedom part, to go to Zohar's question earlier, prioritize the right over the property. So the right to create over the intellectual, the intellectual property right of copyright. So this was all about where do you find the right to create? And probably, let's be fair, as a footnote, it doesn't really matter where you find it as long as it exists. But this is law school, so we want to look a little bit deeper, and we always want to be able to criticize and look at things critically. So the Supreme Court of Canada, as we've discussed, moves towards a user's right, but that user's right is definitely found on the IP copyright side of the ledger. And it's not just the pentology, it's 3 cases before that. We'll talk about all of that towards the end of the course, and we will revisit it. Could users' rights evolve even under this current Supreme Court understanding of it to be a full-fledged right to create? And this is, the question. Is it is the right to mod an expressive right or an IP right? Right now, I think we might be able to establish it as IP right. Don't know, don't see how we have yet been able to found it in free expression and free speech, to be fair. But if you want to find a parallel model where this did happen, look at the law of defamation, look at the Supreme Court of Canada decision in Grant versus Torstar. Defamation law is very much its own thing. But finally, a responsible communications defense, sort of a parallel to a very famous American precedent called New York Times and Sullivan that we don't have time to get into here, came to exist in Canada. And when you read the case, you'll understand that it came to exist through the Charter and modified defamation law. No reason we can't do a version of that to copyright law. But we haven't done it, and that's the point. Final thread. Does moral rights somehow provide some core of a solution? And this is really a tease for things that'll keep coming up in the rest of the course. And I want you to think of moral rights not in the restrictive statutory meaning, at least today. We'll get into the restrictions and the real world of moral rights, but think of the concept. And there's what the Berne Convention says. But basically, moral rights is the right to be known as the author, or, importantly, the right to not be known as the author of something. I don't want to be associated with that, as well as I do want to be associated with that. It's the credit rate It's not, and when you think of moral rights, and it's expressed in the Berne Convention, we're not talking about the economic rights. We're now talking about something that's personal to the creator. The right of integrity, the more or less legalistic definition of integrity, is preventing unwanted distortions. But integrity is more of a philosophical concept than a legal concept. And I refer you to Snow versus Eaton Center, which is just a classic case, and I hope it exists somewhere else in one of the other courses in the law school. But you know the facts. If you don't, you should know the facts. Snow was a sculptor. He made a giant hanging mobile for the Eaton Centre in Toronto of Canada geese. It's quite beautiful. And at Christmas time, the management of the Eaton Centre decided to put little Santa hats on the Canada geese. Snow, who had never signed off, never waived his moral rights under Canadian law, sued successfully to de-Christmas. Well, I'll just say de-Christmas because I don't even, I can't add an eyes onto there without completely messing it up. To de-Christmas his work of art. The work of art remained, it wasn't pulled down. The Santa hats were pulled down. Legally, moral rights can be waived, cannot be assigned, so it is personal. Reflect on that as the takeaway as we go forward, not only when you think of intellectual property law, not only when you think of copyright. Do some of these solutions, do some of the answers in terms of a right to mod, are they suggested by the personal nature of moral rights? In other words, you can mod my work as long as you don't do something that I find terribly objectionable as the creator. And not in an economic sense, because there isn't an economic remedy. And you got to give me credit.
Or not credit.
Or not credit. And then if you just want to do one more piece of gymnastics for later on in the course, think about, try and put moral rights next to privacy and see where it takes you. Those are the things to think about. Can we use moral rights together with, can we strengthen moral rights and strengthen the right to create, right to mod at the same time? And does that take us to a good place? Not just for gaming, but for all digital creativity.
One of the new corrections in the new act is, of course, a provision for parity. Parity would, in fact, allow for manipulation of an existing work. That being the case, even though they have handed in more moral rights, you have also limited them to a certain extent as well by allowing that there could be a parity defense.
Well, I think you're actually doing a very effective bridge to our speaker and where we're going to be going for the remainder of the class. So for now, we are done the creating meme, and we are going into connecting, which is largely what contracts has done to creating. What end user license agreements and TOSs, what that wave rolling over copyright and creation does. And we're going to look at that in terms of, at least the next talk is going to be called Creators, Consumers, and Users, unless I change it. And the thing to think about is, why aren't they all the same thing? Because they really are in today's digital world. So thank you. And Rock, do you want to do an intro?
Yeah, sure.
Okay, thanks a lot.
So we've got Ian Verschaer here. He is the Chief Creative Officer of Roadhouse Interactive. He's also the co-founder. Founded in '09. Roadhouse specializes in, I guess, primarily social games now.
Online.
Online games
Yeah.
now, including Family
Every
Guy.
game is social now.
That's right. Including Family Guy Online. Giggity. So
That was fair use.
that was fair use, yes.
I've known Ian
I need to plug
for
in. A long time.
a
John.
long, long time, and he is one of the absolute cores of the creative gaming community in Vancouver. He can take you a little bit through what he's done, but he is a voice to be reckoned with. He has taught many courses and is an academic in his own right. Ian, do we need to set you up, or are you good?
Yeah, well, if you have an HDMI, that would be awesome, or something. But you have a Mac. I have a Mac.
Yeah, I copied my slides over. So
I have
maybe-
some movies and stuff. So should I just bundle a PowerPoint and then send it
Yeah.
over? Okay.
Um,
Because you guys don't need to spend too much
all right.
time.
Well, let's take 2 minutes. Let's take a 2-minute break.